So we had yesterday's question is on First question was on professions and professional. What are my obligations to her and what steps I could
Should have.
have taken to avoid the misunderstanding. Okay. This is generally like, overview of profession and professionalism. You have to talk about legal ethics and professional responsibility, integrity, competence. Here, what and all will come. 6 months ago, let me share the screen. So first, always I give you a hint that read the question part first. Okay, last portion always will be mentioned about the question. So we will read the question part first to understand where it is, focusing on. Because now in the practice paper, you will see one paragraph or at least one page ka question will be there. In the exam, it might not be so. The fact pattern could go very long because they will be talking about few different chapters together. So what we will do is we will read the end part first and then we will go to the facts. So here we see that what are my obligation to her and what steps could I have taken to avoid the misunderstanding. And of course, topic hint also will not be given, only this much. Now the facts goes as follows. 6 months ago, a woman consulted me with respect to her personal injury matter. I told her that if she wished to retain me, she would have to provide me with the money retainer within 2 weeks. Okay, money retainer within 2 weeks. She did not do so, and accordingly, I assumed she did not want to retain me. I heard nothing from her again, and neither did I follow up from her. Okay. However, this morning she called me and left message with my receptionist looking for her trial date. That means, because of the conduct of the client here, what we can see is the client still thinks that she has retained this advocate, isn't it? Now, so that is what we understand from the fact, but the advocate was very clear. The lawyer was very clear. Lawyer said that you have to pay me money, but within 2 weeks. When they did not do that, she assumed. So I assumed that she did not want to retain me. I heard nothing from her. When did this happen? 6 months ago. So this is with respect to retainer and what a lawyer should do when the client does like this. Go AWOL on us and then they will come back after months and they say that I thought you were my lawyer. It won't be so. Correct. It won't be so. But under what model code provision? So did you see any model code provision with respect to retainer? Yesterday we saw limited scope retainer.
Correct, yeah.
So similarly, there are provisions for retainers also. Let me show
In
you.
like 3.6.
Yeah, we will open entire screen. Model code provision. Yeah. Which one you were saying? Okay, retainers we had limited scope retainers are here, and with respect to 3.6. Okay, fees and disbursement, reasonable fees and disbursement, contingent fees, joint retainer, statement of account, division of fees. Under this 3.6, which one you are planning?
Like where on non-payment of fees we can like withdraw. Oh, sorry, it will come under withdrawal from 3.7.
Yeah, withdrawal. You just saw. Okay, withdrawal from representation. So withdrawal from optional, non-payment of fees. Non-payment of fees. The heading is withdrawal from representation, right? So it will
Yes,
be
ma'am.
3.7. Correct. So always cross check. Okay, even point also it is major difference,
Yeah.
right? So withdrawal, obligatory withdrawal, leaving a law firm, manner of withdrawal, so and so, so and so. Yes. So it is withdrawal from representation, even though we can say that it never started. Practically, it might look like it never started, but she has consulted me. That means lawyer-client relationship has existed.
Right.
Lawyer-client relationship is nothing to do with the money. Okay, because where is our notes? Question, yeah. See, women consulted me. Women consulted me with respect to her personal injury matter. That means I know she has disclosed the information. The lawyer-client relationship existed. First is that question. Okay, whenever PR ka question comes, first you have to look at is lawyer-client relationship is present or not. Even though it is, sometimes after the point you might feel it is redundant, it's already there. Still, writing one line on that doesn't hurt. It always helps in getting perfect marks. Now, what will you write with respect to lawyer-client relationship is that I have an answer opened here. I'll show you that only.
Like
Mm.
first we will establish that she is the client by showing the client's definition, and later on the
Yes.
withdraw.
Yeah, exactly. So we will show that we can write in this manner. Um, Yeah, exactly. How you mentioned, we can say that um, here. Let us give a name to the advocate just to give context. Sarah. Okay, so advocate is Sarah, and women's name. Okay, give me a name.
Serena.
Serena. Okay. So Serena has consulted Sarah. Sarah is the advocate here with respect to Serena's personal injury matter. And Sarah told Serena that if she wished to retain Sarah, then she have to provide Sarah with the money retainer within 2 weeks. Now, here your issue will be whether there is a lawyer-client relationship between Sarah and Serena. Lawyer is Sarah and client is Serena. So in the exam also, obviously, they will give you characters' names and you will use in your issue character name only. So
Oh,
you will start your issue like hmm, lawyer-client relationship between Sarah and Serena. Okay, so this will be the issue, and that is the first part, right? That is the first part. But here, what is the actual big issue here? Second issue here is if there is a lawyer-client relationship, then what are the obligations of Sarah to Serena, and what steps Sarah should have taken to avoid this misunderstanding? Here, there is a misunderstanding that Serena thinks that Sarah is still representing her, right? So, what
right,
are
right.
the obligations of? So, in the presence of lawyer-client relationship, what are the obligations Sarah towards Serena? First one is what are the obligations, and second should be what can she do to avoid the misunderstanding. So what steps Sarah would have taken to avoid the misunderstanding. So I would like to state one thing here that in PR you might see multiple issues. Okay, multiple issues. We are kind of making it much simpler and breaking it down into different parts. But in criminal law or in other topics, we will be going with as much as possible one issue. Okay, as much as possible one issue. Only if two different accused persons and all are given, then only we will go with the two issues. Anyway, that I will tell in the criminal law class also. But don't get confused. You are writing both exams, so that's why I'm saying in PR we will be seeing that multiple issues we will be making. Of course, analysis it doesn't make a difference even if you are writing one single issue here. What one single issue you can write? You can write that what are the obligations of Sarah to Serena and what steps she could have taken to avoid this the misunderstanding. Like that, if you write one issue also, it is not going to make you lose marks. But this is well structured so that when you are writing the answer in the analysis also, step by step what and all to cover. Okay, that is the only intention. Now rules. Rules, of course, in the beginning we wouldn't know. So we will leave that and we will go to analysis part. Analysis part. Conclusion always will be the direct question for what they have asked you. So here, what are the obligations? What steps she could take? If it is a big question, then obviously we will conclude it in a very simple manner and we will write. Now, what is the analysis part? You just mentioned you will start your answer by saying that there is a lawyer client relationship. So now in the analysis part we should talk about lawyer client relationship. First issue we should talk about. So with respect to that, rules also we know what are the rules. Let me open model code. Okay, can you tell model code which provision we are looking at here with respect to definitions, right? We have to look at the, sorry, not that definition, client definition.
1.1 dash.
Yep, 1.1-1 is talking about, so model code rule. Model code rule or we can write like this. Let me cut this and put here. Okay, rule 1.1-1 of model code of professional conduct. Now, if you write this much every time, then of course it's gonna lose you time, right? So once you write, then you mention the short form MC. Model code of professional conduct. Okay. So which is talking about what? Client. We know there are so many things under this, right? So client is there, associate is there, other things are there, consent, conflict of interest, and law firm, lawyer, limited scope retainer, society, tribunal. All these are there. But which one are you referring to? There are no subpoints. So you have to mention it is the client that you are talking about. So you will write, I am talking about the client definition here. Okay. So then the next. So here the rule under the rules part you are just listing. Okay, you are just listing. You're not doing anything more than listing it out. So you are just listing here 1.1-1. Do you remember any case from our classes which talks about lawyer-client relationship, establishment of lawyer-client relationship, which might be relevant here? that it does not exist. I mean, it also exists without formality, right? So under client, we are talking about under client, which one? Do you think it is falling under?
Maybe established without formality, and number two, the commentary when an individual consults a lawyer. No, sorry, not a. Sorry, this one.
Not that. First one, correct.
Yeah.
First one comes, okay, without the formality, right? So we will write entire thing. So anyway, this we can write in the comment, this one analysis part, because it's a bigger thing. We have to connect that and connect with the facts and write. So whatever takes more time, we are not going to mention it here. So we will write it here. So what we will mention in the beginning, you are not supposed to start with the as per rule so and so so and so so and so. Start with the introduction, right? So what you will say? Introductory one line, can you suggest?
Mm, uh,
About lawyer and client.
Honestly, I'm like very bad at this. That's why.
Oh, no problem. We will try. Okay. Lawyer client relationship.
Mm,
Lawyer has a duty to hold strict on all the information. Okay. We'll find introductions. So this is how in the beginning we will have some introduction lines. Relationship must be established. Okay, the written or mm. When a lawyer is approached by a prospective client, they must decide whether to accept or decline the engagement for legal services. In making this assessment, the lawyer must determine whether they are competent to act, whether they can complete the task required, and whether there are any conflicts of interest. Right, all these things they have to see. And of course, this extends to paralegal, but we are not bothered by that now. Okay. So what we can write is a simple sentence we can start. Or also a backup is that you can also start with any of the sentences that is mentioned in your commentaries or anything. Okay. So last time I think I gave you some highlights in some places where it talks about uh,
yes.
yeah, so that also you can use. So from the model code also you can use, or from the notes material also you can use. Let us open our notes material, because I want you to see that like how this entire you know um,
Yeah.
activity goes about, right? So if I just give you the answer, it wouldn't help. So let us see. Lawyer, lawyer, lawyer. In legal ethics, professional ethics topic that we had in India also, how we used to write in the beginning, I believe we used to write lawyering, advocacy is a noble profession. That's how we used to start, right?
Yeah.
Yeah. So like that, some kind of general statement is sufficient to write. Okay. So even in our notes also we can see. For each topic, the introduction goes slightly different, but if you have some general statements ready, that will help you on the day of writing the exam. Okay. So what we can do is we will start writing generally saying that the lawyer client relationship, lawyer client relationship begins when the client or okay, prospective client, right? So they have not become the client yet. When they only reveal some information, then only they become the client, right? Otherwise, casually some stranger is talking to you, that's it. Not in your capacity as a lawyer they are talking to you, isn't it?
Correct.
Yeah.
Or maybe here we can like write something about the retainer. Like
Retainer also we can write, but before that, retainer comes only when there is a lawyer-client relationship already established, right? When
correct.
retaining me for a long-term lawyer-client relationship will come without retainer also.
Right.
Yeah, that's where we have to go. That's the same line where we are going, but we will start with this. So we say that lawyer-client relationship begins when the prospective client approaches the lawyer revealing some confidential information about their case, and then what else? About their case, and seeks an opinion. Correct. No, it's not just they tell, they also seek an opinion. In the point of seeking an opinion only they talk, right? Seeks an opinion. So you can change this sentence by saying that when the prospective client approaches the lawyer seeking for the purpose of seeking an opinion and reveal some information that is confidential about their case. So like that, some paraphrasing you can do, you can change, or you can entirely choose some other line also. But this is very simple way of your saying what you mean by what is in your opinion is lawyer-client relationship, and what is that you understand about this particular concept. Now this is as per the as per the introduction. Now let us go with the facts. So what is the mark for the question we have? How much mark? 20 marks. Right? 20 marks means we have to cover all these for 20 marks. 2 pages. In PR, the count will be like 2.5 pages. So, okay, 2.5 pages if it is going, then we have to write in very short and brief manner only, not too much. So now, as per the rule, as per the rule 1.1-1 model code of professional conduct, the definition of client is provided under the rule 1.1-1 of model code of professional conduct. Correct. We are just saying that the definition is there. Now, in the definition, what are the key points that we have to tell as per this case? In this case, what happened? She has consulted with respect to personal injury, right? So, we have to mention in the instant case, Serena has consulted Sarah 6 months ago 6 months ago on a personal injury matter as the facts suggest that there was a consultation there seemed to have existed a lawyer-client relationship between
Right.
Sarah and Serena.
In the exam, are we able to copy and paste like within the page or no?
No, we are not. I was about to say that when I copy and paste while solving, I usually say immediately.
Right.
Yeah, so there is no copy and paste, but you can drag though. Like you can select one paragraph and you can drag it to some like this.
Okay.
That much you can do, but no cut, copy, paste.
Oh, okay.
Yeah, and even deleting also sometimes like entire paragraph. If I want to delete sudden, it won't go suddenly. It goes very slowly. Of course, it is for our own protection, but sometimes it's so annoying. Like if I had written something like 3 lines and all, recently I was trying to change the entire sentence though, so it was
Mm.
bit annoying. So I was like pressing my backspace like so for so long, but it also was good. Like in that time, that 10 seconds, no, what we should always use is like those microseconds on all we should use in thinking. So if you're deleting something, not just focusing on deleting, na, in that time you can think about what better I can write, like how better I can write this answer. Mm. Yeah. So yeah, that 3 hours will be like constant. Our brain should be like that computer AI. So we should write. Now, this is what the fact says, right? So the definition of client is given in the so and so model code. In the instant case, Serena has consulted Sarah 6 months ago on a personal injury matter. As the facts suggest that there was a consultation, therefore it seems to have existed. Okay, therefore, it seems that there existed a lawyer client relationship, okay, between these two. Moreover, the consults a lawyer on whose behalf the lawyer renders or agrees to render legal service. This didn't happen in our case, right? So having consulted lawyer reasonably concludes that the lawyer has agreed. So in our case, point B comes because the client's action has shown like that, isn't it? Moreover, the moreover, Serena reaching out to the receptionist, office clerk. Who's that?
Nothing is mentioned like that.
Receptionist.
Oh, okay, sorry.
Yeah, left. No, not Serena is the receptionist. Serena called the receptionist. Yeah,
Correct.
Serena reaching out to the receptionist, asking asking for her trial date that suggests something, no? That suggests date suggests that she we have to use the words that is there in the model code. Okay, she reasonably suggests that having consulted having consulted Sarah Serena reasonably concluded that that the lawyer Sarah has agreed to render legal services on her behalf, referring B B of Rule 1.1-1 of MC. Make sense? So we are not directly writing the model code provision as it is. Okay, we are applying that to the facts and we are saying from where did we find it out, right? From where are we getting the assumption, or always you might see me writing in this lines, okay, like it suggests, it seems, like that and all, because that is how I feel. Like, we are not concluding that this is it. We are taking the facts and we are assuming on that basis, right? Whatever they have given in the facts only, we are sticking to that. So because of this particular point, I feel like this particular provision applies and this is how it applies. Okay, clear now? So therefore, okay. Additionally, you can write about commentary, right? We have to write about formality. Additionally, retainer point, we will say that additionally, this Sarah was of the impression that there was no relationship, right? Because of what reason? Because she had told that if she would wish to retain advocate, she would have to provide with money retainer within 2 weeks. Okay. Additionally, Sarah had instructed Serena to to provide with money retainer within 2 weeks of the consultation. 2 weeks of the consultation to confirm the lawyer to confirm the retainer confirm the retainership confirm the retainership. Confirm the retainership. Here we need to remember that the lawyer-client relationship that a lawyer-client relationship may be established without formality as per rule 1.1-1 commentary 1 of the MC. Remember to note that lawyer-client relationship may be established without formality as per rule so and so, so and so. Therefore, the lawyer-client relationship between the Sarah and Serena are independent independent, are independently, are independently existing, without retainer, okay. So this is how we distinguish, okay. Even though they have given certain points, we are either saying yes, because of that particular point it is existing, or we can say that that particular point doesn't matter here, okay. Now what she should have done, that we will say next, but for existing of lawyer client relationship, this we are only focusing on the first issue. For first issue we wrote this much.
Correct.
Yeah, you're getting some understanding, no? First two questions and all, I will help you in writing like this complete answer, okay? Later on, you will write the answer, then I will give a brief of it, which you can, write in detail.
Oh,
Because it is for the first time you're writing PR exam ka answers, so you need a little bit of, understanding of how it looks like, right? That's only reason. Now, in the presence of a lawyer-client relationship, now that there is a lawyer-client relationship, what are the obligations? We can't talk about obligations whenever they give, in the question, we can't talk about obligations without the presence of lawyer-client relationship. So we have to say that there is a lawyer-client relationship, and then we are now talking about what are the obligations. Now, secondly, as the lawyer-client relationship exists between Sarah and Serena, between Sarah and Serena, the Serena, the lawyer Sarah has some obligations towards her client Serena. So, what are these obligations? The obligations include, what are the obligations? What are the obligations of a lawyer as far
like
as we have seen?
we saw yesterday, like also in like quality of service, we can see that there was a rule for like timely communication and everything.
Yeah, yeah. What are the obligations of lawyers?
Yeah, 3.2-1, commentary 3. A lawyer has a duty to communicate effectively with the client.
Hmm. 3.3.
Sorry, 3.2-1,
Okay, 3.2-1.
commentary 3.
Lawyer has a duty to communicate effectively with the client. Communicate effectively with the client. What is effective will vary depending on the nature of the retainer, the needs and sophistication of the client, and the need for the client make fully informed the decisions and provide instructions. Lawyer ensures the matter are attended within reasonable time. Okay, this one is good. Yes, of course, we can use that. Quality of design leads the generally expected to read and apply the conceptual competence. Quality of service comes later. Client should basically tell that there is clear communication. Okay, that section that the commentary that you have told is perfect. Now let us look for the retainer point.
So basically, I was saying that he should have she should have communicated that 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 they are assuming that she's not going with them as their legal counsel because she hasn't paid within 2 weeks. So they could have like sent an email regarding that.
Yes, yes, yes. Yeah, there is a provision also for that. Withdrawal, we know, right? Withdrawal will go. Mm, but in this part, mm, okay, this I just wanted to add over here. She said 2 weeks now, but 6 months has passed as per the fact, no? So just
Correct.
wrote that. So here the obligation include, sorry, I missed your point here. Let me write it. 3.3.2
-1. It's
highlighted. Include the effective communication, right? Include effective communication, referring uh, model code rule 3.2-1 commentary 3. Include effective communication. So we are talking about effective communication. Now we can write this on our board. Bold. Next. Also, we added this commentary now here. We will add over there. Okay. Anything else? B of the word. Some of the formatting things I was just doing. So here, not really necessary that you should write entirely like full description like this. This is I'm saying up to this level you can do, but of course in the exam, if it is not possible for you to write in that moment very beautifully, mentioning like this, at least write it in short form. That is also fine, but you have to indicate in the rules part. You have to just indicate this is the provision I'm talking about. Okay, even if you're not writing this and all, like the part B and all, it's fine. At least you're mentioning this much, and this commentary additionally, commentary one of the model code, this one, or here only you're putting command writing. There are so many other ways to write it also. So you can use those methods, but as much as possible while we are practicing, you use this method. When we are practicing sample papers of 100 marks in with the timer, no, that time we will see how much you can write, and you can cut down your time in this area. so that you can spend more in the analysis part. Okay, so yeah. Next, she had the obligation. Now, this effective communication of what? In the instant case, what is the effective communication? In the instant case, Sarah must have had an effective, must have effectively communicated to Serena that there that in the, उन्होंने सिर्फ इतना बोला ना कि if you want to retain me, then this is the like you have to pay the money fee. That's all. But उन्होंने ये नहीं बताया कि consequence उन्होंने नहीं बताया, right?
Yeah.
So yeah, that's what. So he effectively communicated to Serena that in the absence of money retainer within 2 weeks, the lawyer client relationship would cease to exist. Right? This is the fact that is coming, that we are talking here. Now,
Right.
with respect to, this is why I told you earlier, I think I've told कि IRACs जो है, we cannot use IRACs as it is, copy paste from whatever is ready made, because don't you see like 99% of it is what is there in the facts only.
Yeah.
Yeah, so it cannot be that copied, from the ready-made model, ready-made IRACs, but it will only guide us. It will guide us that okay, in this particular type of question, what and all model code comes, model code provisions I have to hit. That it helps, but how to write the answer analysis part, that is totally up to the candidate. Now, let us go to retainer part, our withdrawal part. Okay, so that is the third part. Obligation to effective communication. Then, what steps she should have taken to avoid misunderstanding? Further, to avoid any such misunderstanding about the existence of the lawyer client. Once we study more obligations of the lawyer, no, now we have only seen integrity, competence, and all, so it's fine. But once we have seen more obligations, where I am mentioning, na, among others, there you can like write comma, 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 and write more obligations here. Okay, whatever you learn, some in very brief way you can mention. Okay, the obligations of a lawyer in lawyers are duty to be honest, duty to candor, do everything you can write. Then you can write including, which includes effective communication also as per so and so. You don't have to write everything, but whatever you feel like, at least one or two you can write. Next, to avoid any such further misunderstanding about the existing lawyer client relationship, usage of the relationship. Sarah should have. Now, what she should have done? Let us see. 3.7. We have withdrawal.
Reasonable notice is notification to the client, the commentary to.
An essential element of reasonable notice is notification to the client unless the client cannot be located after reasonable efforts. Let's see anything if specifically applies, otherwise we'll go to that. Optional withdrawal. Serious loss of confidence not there. Non-payment of fees. If after reasonable notice the client fails to provide retainer or funds on account of disbursement of fees, the lawyer may withdraw unless serious prejudice to the client would result. When the lawyer withdraws because the client has not paid the lawyer fee, the lawyer should ensure that there is sufficient time for the client to obtain the services of other lawyer, and for that other lawyer to prepare the adequately for the trial. That means last minute even Sarah cannot say that I am not your lawyer. No, like that she can't say, because she also did not do what the model code is saying. She should have informed that our relationship has ceased to exist, and if she had done that earlier, then of course the Serena either could have paid the money and retained her, or she could have found another lawyer, and another lawyer also might have had a sufficient sufficient time for preparation. Now, withdrawals from criminal proceedings. This is personal injury is also criminal case, right? So there also we have to see. We have to do the withdrawal in such a manner.
Yeah, actually, this one will apply. The one in the criminal proceeding,
Yeah.
3.7-4.
Mm-hmm.
A notifies the client in writing that the lawyer is withdrawing because of fees has not been paid.
Mm-hmm. Manner of withdrawal also is important. Okay, I was just looking for this. Manner of withdrawal, we can write duty of successor. Okay, done. So what? Just make sure once you are covering all the provisions that could be, possibly could be applicable, and once we rule out on okay, this does not apply, then the remaining one we can check out. So non-payment of fees is what we are going to talk about mainly. Optional withdrawal will not come. Okay, from here, right? So we will definitely talk about, let's make a list. Rule 3.7-3, that is non-payment of payment fees. Then withdrawal from criminal proceedings, 3.7, isn't it? 3.7-4. 3.7-4, withdrawal withdrawal criminal proceedings. If a lawyer has agreed, let us read this. If a lawyer has agreed to act in criminal case, and interval the interval between a withdrawal and a trial of the case is sufficient to enable the client to obtain another lawyer and to allow such other lawyer adequate time for preparation, the lawyer who has agreed to act may withdraw because the client has not paid or agreed fee for other adequate costs, because the client has not paid the agreed fee or for other adequate costs, provided that the lawyer notifies the client in writing that the lawyer is withdrawing because the fees have not been paid or for other adequate costs. Accounts to the client, the monies have received on the account fees disbursement. Now, accounts to the client for any monies already received, then account देना पड़ेगा. Notifies Crown Council नहीं चाहिए. Okay. Okay, complies with the okay. Lawyer who has withdrawn because of the conflict of the client हमें apply नहीं होता. The lawyer agrees to act in the criminal case, sets out the trial. Another lawyer के लिए sufficient time देना चाहिए. Lawyer who agrees must not withdraw because of हाँ अगर effect हो रहा है तभी in case effect is too much then definitely they should not withdraw only because of non-payment of fees. That situation is there. Okay, remember this one. Not for our case, but in the situation where if they have given key, okay, Sarah is actually tomorrow is her hearing, and today she has approached you and she expects you to come there tomorrow in the hearing. Then definitely you should go. You should not wait for your fees because our obligation, professional obligation says that first we should always look out for representation. Okay. बाद में money comes secondary, but if there is sufficient time and all, of course later on we can file a case against the client also, no, for non-payment of fees. We can always make them pay later. It's not that they are not supposed to pay you or something or do it freely, but we should not wait for the payment of fees, and because of that the client should not be suffering. Okay, that's why first day only, when they come for the consultation only, in Western countries and all, they get everything in writing. Retainer
Yeah.
only they will take. Yeah. Only in India that doesn't happen. I think slowly it's happening, but it will take time. Mm. If the time is not sufficient, then non-payment of fees is not a good reason to withdraw. Okay. Obligatory withdrawal will not come. That's it, no? Manner of withdrawal, yeah. Accordingly, manner of withdrawal also, we will mention rule 3.7-8. When the lawyer withdraws, the lawyer must try to minimize expenses and avoid prejudice to the client, and must do all that can reasonably be done to facilitate the orderly transfer of the matter to the successor lawyer. On discharge of the or withdrawal, lawyer must, okay, we should write this one, 9. First one, not really concerning our case because we are not in the middle of the trial, right? So there is no mention about fact in the facts that we are in the middle of the trial, so and so application is going on. Then I could have written this one. Here it doesn't make sense. I don't have facts to connect it with. That's why I'm not writing. So I will write about notify the client in writing, stating the facts that the fact that the lawyer has withdrawn, the reasons, if any, for the withdrawal, and in case of litigation, then the client should expect that the hearing or trial will proceed on the date scheduled, and the client should retain a new counsel promptly. Subject to lawyers' right to lien, deliver to all the clients so and so papers, any implication of trust conditions, so and so dealt with, promptly render account of fees, cooperate with the successor lawyer, comply with the application rules. Here, no other places money they are not talking now. Okay. Payment of fees, if anywhere it is there, you can write about that commentary also. Okay. So now I will stick to the notification in writing, stating these points. Okay. I will stick to these.
So basically, if we just do not write rule 3.7-3 and 3.7-4. Oh, sorry. If we don't write 3.7-4, the criminal proceeding one, that's okay, right?
If we don't write,
Yeah.
no, we should write because here it is very clearly mentioned ki in the facts. That's why they suggested, na, it is injury, personal injury matters.
Correct.
Yeah, they are giving us hint that you should write about this.
Okay.
And here also with see some places and all they will mention keep non-payment of fees is not a not a reason for withdrawal. You are not allowed to withdraw if hearing is tomorrow and you are waiting for money. That should not happen. Okay.
Okay.
Yeah, but criminal proceedings also there is agreed fee. If it is not paid also they can withdraw, only provided that it will not cause problem to that particular client.
Okay.
So this is important. And writing 3.79, that is notify the client in writing about withdrawal. So now these three provisions I have to write in my answer. Then our answer would be complete. So what I will do is adhere to the following model code, following professional obligations, professional obligations stemming from the model code of the. Okay, so here, therefore, so apply those to the facts and right now, therefore, as per hmm, as per the rule 3.7-3, the lawyer, we will write the name Sarah. As per rule 3.7-3, Sarah has Sarah may. Okay, she has shall, may, and all as much as possible use as it is. Okay, Sarah may withdraw withdraw from the case of Serena for the non-payment of fees unless serious prejudice to Sarah would result. That also we don't know as per the fact. So don't assume that there is no serious injury to Serena that would be happening. So we will always be, vague about it. Like we will always say that if it is not resulting in serious prejudice, then it is fine. So we'll say that in the case of Sarah for the non-payment of fees, unless serious prejudice to Serena would result. Now, moreover, commentary 1 of this rule. This is why we should have speed typing skills so that uh, we don't have, even though we don't have copy paste, it should not be problematic because in PR we have so much to type. Moreover, as per rules on commentary 1 states that when the lawyer withdraws because of this thing, let us see. When the lawyer withdraws because the client has not paid the lawyer's fee, the lawyer should ensure that there is sufficient time for client to obtain the service of another lawyer, um, and for the other lawyer to prepare adequately for the trial. So we will write such as mandates. So it is kind of a mandatory, right? We should make sure that this happens. So mandates that when Sarah withdraws because the client has not because Serena has not paid her fee. The she should ensure that there is sufficient time for Serena to obtain services of another lawyer and for the other lawyer to prepare adequately for the trial. So under these conditions, definitely Sarah can withdraw. And how she can do it? Now, okay. Moreover, in criminal proceeding, ours is a criminal proceeding, right? So criminal proceeding, that is in moreover, the instant case is about a personal injury matter and being a criminal proceeding. Rule so and so of model code applies here. And what point exactly you want to talk about here? Notifies the client in writing with that a lawyer is withdrawing because fee is not paid, right? So this we had to applies here. And as per point A of rule 3.7-4 and 3.7-4 and our this thing
3.7.
3.7-9A. Both are saying the same thing. So I would, as much as possible, I would like to write less, right? So, but my answer also should have indication of I know the answer, right? So like this we can write as per this rule and that rule. Sarah should have provided the withdrawal in writing to Serena as soon as the 2 weeks had lapsed in order to avoid any any problem. What is called
Misunderstand.
prejudice, huh?
Okay.
What did you say?
Misunderstanding.
Misunderstanding, yeah, good. In order to avoid any misunderstanding, which lead to prejudice to Serena. That is has caused her only no problem. Conclusion. Therefore, based on the above analysis, Sarah having the professional obligation. What is your final question? What are my obligations to her and what steps I could have taken for missing? Okay. Sarah having the professional obligation of intimation the Tara had the professional obligation of intimation of the withdrawal in writing to Serena in a effective manner. Done.
Okay.
Okay. So this is the answer for question number 1. Practice. Okay. So I will be sending you this answer, okay? So that
Sure.
you can have a look at it, but improvise. So I
Correct.
have written the gist that, okay, this is how you have to write. So those last part was there, no, with respect to, retainer and all, like you can write little more, but don't reiterate this one. What do you call it as model code provisions? As it is model code provisions, never mention. Okay, just link it like how I have mentioned here. And if you are able to find cases from the definition of client, if I have provided in the notes, just check if we get cases, you can mention over there. Okay. But as and when we go further, we will be covering more concepts and, you might find more cases uh, you to write, but in the practice paper do not mind if we are not getting, because most of it will be like very small portion of the topic, right? So most probably will not have much cases to write. So yeah, then today we will just look at model code provisions, so that this one practice question is done. Second one you have written, no? Would you like to tell me the answer, and then we can go ahead with the confidentiality today?
So actually, I have like used confidentiality only over here. That is 3.3 dash 1. So, a lawyer at all times must hold strict confidence all information concerning business and affairs of the client
Hmm.
acquired in course of professional relationship and must not divulge from any such information unless the expressly or impliedly authorized by the client.
Yeah.
So I'm just using this on this basis. I have like like
Made over there.
like based my whole answer on this one.
Okay. For the second question.
Yeah.
Okay. 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 Let me. Okay. Let us see. Sadia represented a client in a matter that she gained media, in a matter that has gained her media attention. The trial is in progress, and Sadia's client was wants Sadia to read a statement to the press prepared by the client. Since Sadia has her client's consent, is Sadia permitted to comment on her client's matter to media? Topic: lawyer-client relationship, preservation of client confidences. Yeah. So, what you mentioned that you have based your answer on confidentiality, right? So, unless expressly impliedly authorized by the client. So, part A applies here, correct? Because this particular point says that if your client is giving the permission, then you can reveal.
Yeah.
Correct? Yeah. Correct answer you have written. Because it's a relatively smaller question also,
Yeah.
right? So you will talk about lawyer-client relationship, then come to this section. Under that section, what and all points you can write commentaries, different commentaries, and there are case laws also, which we will be learning,
Sure.
out of which we can see. Okay, so let us have a look at this provision again. Okay.
And Just one more question. Like we have to like, let's say for example, this like uh, rule is applied, right? Like if there is any other similar rule, we should like mention all of those.
Yeah.
Okay.
As much as relevant provisions you are able to list, that much it is good.
Okay.
Now here in chapter 3, it is about confidentiality. We know the concept of confidentiality, right? So the lawyer must not reveal any of the confidential information that has been shared by the client to us, or in the course of the this lawyer-client relationship, whatever we have learned about them and the case. So that is a confidentiality gist. Now, what does our model code provision talk about this? Confidential information. A lawyer at all times must hold strict confidence of all information concerning the business and affairs of the client. Business and affairs of the client acquired in the course of the professional relationship and must not divulge such information. Any such information. All information. All information concerning the business and affairs of the client. Now, unless expressly or impliedly authorized by the client or required by the law to do so. There are exceptions to the confidentiality. Okay, some are statutory like this, some are from different case law also. We will get some exceptions. So one is expressly impliedly authorized by the client, required by the law or court to do so, required to deliver the information to the law society, or otherwise permitted by this rule. So there are exceptions which permits the confidential information to be revealed. Can you give me some of your understanding about, like, under what circumstance other than what they have told? Okay, unless other than the client's express or implied authorization, do you think of any reason by in which lawyer is compelled out of, like, compulsion, he should reveal such information?
Uh, like uh, like lawyer has also a duty towards the society, right? As we saw,
Yeah.
if like any information that is going to affect the society as a whole in the future or something,
Mm.
like I had read like before, like if like there's a case uh, for example, if there is going to be a terrorist attack or if someone is going to be under danger, then the lawyer can reveal
Yeah,
such information.
correct, correct. Yeah. So if there is any danger to public or another individual,
Yeah.
if the client is planning to commit some crime, fraud, okay, so there are it is called as, some of the exceptions that is provided, like, future harm or public safety exception. And there is mm, okay, and there are others which are mentioned in our notes. Okay, so in between different paragraphs, we will see which will be talking about different types of exception. At what point of time, basically, this particular lawyer can reveal the information, confidential information. One is future harm or uh, public safety exception, crime exception. Then we have one second. Innocent at stake exception, crime or fraud or criminal communication exceptions. When the client says that, yes, I am, I have committed this crime, this is the weapon, and so. And public safety exception, innocence at stake exception, when we know that our client has done the thing, but other innocent person is at stake because of the lies that our client has told, or by keeping our mouth shut, someone else will be, at stake.
Right.
Then legislative exception, when the legislations, like some of the act, they will only mention in the provisions that under this is circumstances, the lawyer client privilege will not be considered. It will not be supported by lawyer client privilege. Okay.
Also,
And
one more case that we saw in, I think, criminal law,
hmm,
that the lawyer had purposely did not disclose uh, the other party's health condition when it came across to him, like being a severe cancer, being cancer or something we had seen.
brain aneurysm, yeah.
Yeah, yeah, yeah.
Mhm. Correct. So we do have, that responsibility. So that brain aneurysm case, what happened is that there were two views in that case. One view is that that person was zealously representing the client. So should he be punished for doing his job? And secondly, they said that lawyer also has, duty towards the public and other party and the court and all those things. Lawyer has to see that, okay, because of my action or my client's benefit, how much loss it is, suffering to others. But ultimately, the court and the law society over there said that, no, he was simply zealously representing his client, and he can do so. He can do so because ultimately he was just doing his job, right? So
Perfect.
it was in professional responsibility only, starting chapter,
Okay. Okay.
because it's criminal trial, no? It quite it get confused. Then there are special circumstances also where we can see that lawyer-client relationship will be, could be breached in certain conditions. So let us have an understanding about this. So there could be a question where they ask about under what circumstances in which a lawyer can disclose his client's confidential information. Okay. So here we have to first understand confidentiality is essential to lawyer-client relationship. Correct? So confidentiality is the most important. Otherwise, they'll not come and tell us no what it is, what has happened. We won't be able to give them the fullest of defense that they require. So confidentiality is essential to lawyer-client relationship. And if the clients cannot trust lawyers with all relevant information, it would be difficult for a lawyer to properly do their job and prepare for all possible outcomes. The client needs to trust that the information given to a lawyer will remain in confidence and cannot be compelled by law. Without this protection, the client's right to fair trial would be compromised, as clients won't have access to the best of defense he can get without being able to disclose that he can get without being able to disclose everything to the lawyer in confidence. Hence, the lawyer-client privilege is vigorously protected by law. The client the lawyer-client confidentiality is central to lawyers' ethical and professional obligations. So, these exceptions are available, of course, but that is not taken lightly. It is very rigorously protected. The lawyer-client relationship is very rigorously protected. The confidentiality is protected. This privilege is protected unless and until it is such serious condition that then only they will uh, try to breach it and force it out of the lawyer to reveal such information. That doesn't happen every day. Okay, that is rare circumstances only. Now, understanding the concept of privilege and confidentiality. So, what is the difference between privilege and confidentiality? Do you see any difference here? It might sound very similar, right?
Yeah.
Mm.
Mm,
Any Any point you would like to say what you understand about the privilege and what you understand about confidentiality?
I'm not able to think of any right now.
Okay, no problem. So here, confidentiality and privilege arise out of different sources. Okay. So what are the sources? Confidentiality is an ethical obligation whose source is derived from the codes of ethical conduct created by the law societies, such as our model code. Breach of confidentiality can result in disciplinary action initiated by law societies, whereas privilege is a legal obligation that is that is derived from the court of law. So this confidentiality is coming from our model code. We have the whole chapter also, chapter number 3. But privilege, whereas privilege is coming from the legal obligation. It is a legal obligation coming from the court of law. The concept of privilege is a substantive legal principle which has gained constitutional status as part of principles of fundamental justice. All information, you might have heard, it's not just lawyers, solicitor client privilege. Other than that, also we have spousal privilege, isn't it? And doctor patient privilege. So there are so many different kind of legally protected privileges we can see. Not all are coming from model code, right? So privilege is coming from law, legal obligation that is coming from court of law, but this confidentiality is stemming from our model code. All information received by a lawyer in relation to the client's affairs must be kept confidential, whereas privilege communication is only communications that is had between a lawyer and a client for the purpose of obtaining a legal services. Now, do you see the difference? There is a slight difference. All information received by the lawyer. That means what's his age, what's his daughter doing, what do they what did they eat for breakfast today morning? Everything is confidential, but they are all not privileged, isn't it? So they are what informations are privileged? Privileged communications is the only communication that is had between a lawyer and a client for the purpose of obtaining legal services. Only about legal advice. That means the facts of a particular matter, the statements, the situations, the circumstances related to that matter, whatever he told, whatever is there about the client's information that I got, that is privileged communication. Privileged communication is generally communications received by the lawyer from the client, whereas the confidential information can come from any source. That means confidential information can come from the file, can come from the spouse, can come from the kids or something, whatever the situation, circumstances, witnesses, anything. Anything I receive of my case, of my client, all those are confidential. I should not reveal it. Now, both privilege and confidentiality requires a lawyer-client relationship. However, lawyers should not disclose information they receive in consultation, even though person being consulted does not end up as a client. It is to be noted that both confidentiality and privilege can be waived by the client. And both confidentiality and privilege has exceptions. So both of these has exceptions. Both of these can be waived by the client. Client can say that yes, you can tell anybody you want. They can do that. And also there is a point with respect to lawyers should not disclose any information, even if it is just a consultation. Even if it is just a consultation and the lawyer is not being retained. So this is the loophole, and many of these multimillionaires and all, they use these loopholes, and what they do, they just take appointment of top-notch lawyers, and they go and take a consultation, just one consultation, so that they have discussed that their case. Now, even though they do not approach them, like retain them as lawyers, now what happens? Those lawyers are bound not to appear for the other party,
Okay.
isn't it? Yeah. So this is what the top-notch lawyers get screwed
Right.
like by these millionaire clients.
Right.
Yeah, yeah. That happens. Maybe that's why lawyers are so costly in the Western countries.
Exactly.
Yeah, makes perfect sense now.
Actually, yeah.
Yeah. And there is this article also. I'll send you this answer. Have a read through of this article, what we have understood. We just have had an introduction to confidentiality. And basically, we only solved that particular, question answer today. And I would like to see the full-fledged answer for question number 1 from you and also question number 2. And
For
tomorrow, yes. Okay.
and also
So,
for the criminal, I'll send you.
yeah. Take your time, but yeah, criminal code as much as possible. You send first that, and then this you can start preparing.
Okay, sure.
Okay. This answer also I will. Do you have this PR assignment too? I think 4 of them also I might have shared.
I think yes.
Just check. If you do not have, just let me know in the message. Okay. And I will be sharing those. And yeah, that's it for today's class. We basically had an understanding of how to write the IRAC answer. And in the next class, we will look at confidentiality chapter in its whole entirety. We will understand the concept and the case laws, everything we will cover. Okay.
Sure.
Okay. Thank you.
Thanks a lot, Vidya. Thanks.
Hi, Sunita.
Hello, hi Vidya. Good morning. Just I joined
In the class.
to